Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 117, and we have of course the usual three cases for you in this podcast. The first deals with a really good example of the right and the wrong approach in an unfair dismissal case to try and establish a fair dismissal. It also deals with a useful procedural point, and we get to say I told you so, which of course we're not going to. Well, maybe we will. Secondly, the Court of Appeal has had to consider a lengthy tribunal decision on whistleblowing matters, and there's some good lessons coming out for employers trying to deal with a whistleblower and taking potentially disciplinary action against them. Thirdly, we have a case that's going to be quite helpful for employees where they're considering setting up after leaving employment, going into competition. But the employers too, I think, are going to find it useful in the context of the sort of things a court will think about on springboard relief. As usual, please don't forget you can access the podcast via iTunes. It's on the Mayor Brown website, it's on YouTube, and our Twitter feed, Nicholas Robertson at Nicholas ROBER11. And that's where we put out the links for the cases discussed too. So, first case, Arnold Clark Automobiles Limited and Spoor. This is a case dealing with two short but important points in the context of unfair dismissal. First, the case explains why it's always necessary to consider the particular facts of the case rather than treating it as something to be decided automatically. Secondly, and I think very importantly, it also has some guidance on the Ramphal decision, which has been quite troubling for HR departments. Let me explain. Background is that the claimant had worked for the employer for something like 42 years with a perfectly clean disciplinary record. The company is a very large one with something like 10,000 employees, including 15 HR staff. The claimant was responsible for guidance to apprentices working at the company. He had what appears to be a slightly difficult conversation with an apprentice, and this resulted in an argument with one of them, during the course of which the claimant momentarily lost his temper and made a grab for the apprentice. Depending on which version of events you believe, he either grabbed him round the throat or grabbed him, quote, in the vicinity of the throat, unquote, which sounds either way like a Bart and Homer moment. Claimant realised, of course, he'd been out of line, and the next morning he went and apologised directly to the apprentice. He was then called to the manager on site. The manager took the view that it was a momentary incident and did not merit full disciplinary action. Instead, he sent an informal letter of concern to the claimant. However, he reported it up the line in the normal way, indicating that in his view it was, quote, handbags, unquote, between two guys, and not worthy of any further action. Pausing there, the tribunal felt compelled during the tribunal decision to explain what the term in this context handbags meant. However, it appears that HR, who became aware of matters, decided it wasn't handbags. It was in fact a rather more serious matter, and they convened a disciplinary hearing. The two HR managers, the first one at the disciplinary hearing and then the second one at the appeal hearing, took the view that this was gross misconduct and dismissed him. Unsurprisingly, he claimed unfair dismissal. The company's position at the employment tribunal hearing was that the claimant's length of service and previous good character were not matters to which HR paid or were obliged to pay any attention in coming to the decision to dismiss. It was asserted by HR that there was a zero tolerance policy to any incidents of physical violence. The employment tribunal found the decision to dismiss was unfair, the claimant had contributed 50% to his own dismissal, and so compensation was reduced accordingly. The company appealed to the AT, arguing that the tribunal had substituted its own view for that of the company during the disciplinary process. The EAT, having found the original tribunal did make some errors in its judgment, agreed that it would determine matters directly rather than sending matters back to the employment tribunal to be reconsidered. On the main issue, the EAT confirmed the decision was unfair and that the claimant had contributed 50% to his dismissal. The EAT decided that the tribunal was entitled to disregard HR's assertions that there was a zero tolerance policy towards acts of physical violence. There was no evidence of such a policy. Indeed, the EAT pointed out, the company's own disciplinary procedure said that acts of gross misconduct would, quote, normally, unquote, result in dismissal. so much for zero tolerance. The company were therefore wrong to ignore altogether the claimant's length of service and the previous exemplary disciplinary record. Pausing there, I think this is a really good example of why employers need to consider each case on its facts. Clearly someone with very long service and an exemplary disciplinary record can expect those factors to be taken into account, even if they would not ultimately excuse the conduct in question. For example, if the claimant here had 42 years service and an exemplary disciplinary conduct, how likely was it that this sort of incident was going to happen again? If it would not happen again, that's clearly a fact that can be taken into account when deciding on the appropriate sanction. Here, the claimant had realised what he'd done wrong, he'd voluntarily admitted what had happened, he'd apologised on several occasions, and the manager had clearly taken the view this was not conduct that was particularly serious. In the circumstances, the tribunal's decision is hardly surprising. However, as I say, the important point to take away is the need to consider each case on its facts and look at individual cases rather than simply applying a mechanistic approach. Secondly, and I think even more importantly, the Employment Tribunal had originally decided that the dismissal was unfair on the grounds that HR had taken the decision as to whether or not to dismiss. They said this was a conflict with the decision in the Ramphal case. Now, the Ramphal case, if you remember, indicated that HR's roles in disciplinary proceedings should be limited to providing advice and guidance to the disciplinary decision maker on matters of procedure and precedent. We'd suggest in the light of that disciplinary procedures could be changed so that HR could be involved expressly as formal decision makers. It seemed to us that this was a way forward because it would allow HR to continue to play the extremely valuable role it does in disciplinary processes. Here, we have evidence in this case that this is indeed a permissible way forward. The EAT allowed the appeal against the tribunal's decision that said the dismissal was unfair because HR had taken the disciplinary decision. The EAT said the Ramphal case had no part to play because HR were the actual decision makers in this case. Now, it seems to me that if employers can empower HR to be the actual decision makers, then equally clearly HR can be empowered to be the joint decision makers alongside line management, if that's what the disciplinary policy makes clear. So that was the case of Arnold Clark Automobiles Limited and Spoor. Next up, Bayat and Croydon Health Services NHS Trust. This is a Court of Appeal decision on what sounds like a very, very long-running and distressing dispute within one area of the Croydon NHS Trust. The Employment Tribunal decision covers some 201 pages and the Court of Appeal decision is 36 pages long, so what follows is obviously only a brief summary. However, it does have some useful pointers on handling whistleblowing complaints. The appellant is a consultant cardiologist and worked for the Trust for 7 years until he was dismissed. The appellant had set up the interventional cardiology service, but as the team expanded it became dysfunctional, and attempts to resolve matters by, for example, a formal mediation process did not succeed. The two main consultants, one of whom was the appellant, clearly did not get on at all, made complaints about each other. There was then an incident where a nurse on a working team was suspended, contrary to the wishes of the appellant, who felt that it was irresponsible to suspend the nurse during her working day. Indeed, the appellant sadly took the view that the indirect consequence of this was that her absence contributed to a patient's death later that day. There were then a whole series of disclosures by the appellant complaining to the Trust about the suspension of the nurse, questioning the morale of nursing staff, raising concerns over patient safety, and so on. These disclosures were made over a period of a couple of months. The Trust investigated those concerns under their whistleblowing policy, but decided there was nothing to the complaints, and that they were entirely without merit and gratuitous in nature. The appellant was then suspended for 9 months while a report was put together investigating the allegations that he'd made false accusations when he purported to make these disclosures. This in turn led to 9 disciplinary allegations being levelled against the appellant. For example, it was alleged he'd made unsubstantiated and unproven allegations about unsafe service and unsafe staffing levels within the service at Croydon. There was then a disciplinary procedure which went over 6 days and interviewed 12 witnesses, at the end of which 6 of the charges were upheld, and then the appellant was dismissed. So, you have it here, classically. Individual raises whistleblowing complaints and is dismissed because the complaints were groundless and therefore unprotected. It's alleged. The appellant brings proceedings for ordinary unfair dismissal and for automatic unfair dismissal on the grounds that he'd been dismissed for having made protected disclosures. For part of the time, the relevant law, the Public Interest Disclosure Act, required a disclosure to be made in good faith if it was to be protected. although the law was changed before the final disclosure was allegedly made, when instead the disclosure had to be made in the public interest and no longer in good faith. The Trust defended the case on the basis that he had been dismissed for misconduct and it had been reasonable to dismiss him for that reason. None of the disclosures were made in good faith, the Trust said, and the final disclosure wasn't made in the public interest. Well, the Employment Tribunal upheld Dr. Bayat's claim and found that he had both been unfairly dismissed for ordinary unfair dismissal purposes and on the basis that he'd made protected disclosures. The appellant was found to have acted in good faith and reasonably. By the time the case reached the Court of Appeal, there was no longer any legal challenge to the finding that the disclosures the doctor had made were qualifying disclosures under the legislation. So the main issue for the Court of Appeal was, why had the appellant been dismissed? Was it in connection with the allegations? The Trust case was that the tribunal had made an error when it considered what was the principal reason why the appellant was dismissed. The appellant's position on this was very clear. The Trust had dismissed him for making unsubstantiated and unproven allegations. Once the tribunal had found, and it had now been accepted, legally speaking, that the disclosures were protected disclosures, it then followed he'd been dismissed in breach of the whistleblowing legislation. The Trust's response was to say that the reason why the Trust dismissed the appellant was that it believed he had made unsubstantiated allegations. On that basis, the Trust had not dismissed him for making protected disclosures. It dismissed him because it believed he'd made unsubstantiated allegations. The Court of Appeal rightly, I think, gave this argument pretty short shrift. It was inescapable that the legislative intention was to have an objective means of establishing whether or not an employee was entitled to protection as a whistleblower. The Trust's arguments would have meant, the Court said, that an employee would only get protection if the employer believed that they were entitled to protection. That would be unacceptable in policy terms, as it would significantly reduce the scope of the protection of the legislation. In my terms, the obvious point would be that the more unscrupulous an employer was, the less the employee would have the chance of claiming whistleblowing protection, in the circumstances where he or she was most likely to need protection for raising matters of concern. Court of Appeal commented that papers clearly indicated that the Trust viewed the appellant as a troublemaker, and that this belief on the part of the Trust had appeared to be sincere. But the Court of Appeal said it's in the nature of whistleblowers that it is all too easy for an employer to view whistleblowing as difficult or awkward, and this can cloud the basis of the employer's judgment about whether the disclosures in question do in fact have a reasonable basis and are in the public interest. Quote, if there is a moral from this very sad story, it is that employers should proceed to the dismissal of a whistleblower only when they are as confident as they reasonably can be that the disclosures in question are not protected, or that a distinction can clearly be made between the fact of the disclosure and the manner in which the disclosures are made. So, at the end of a long judgment, the key determination is that an employer is not going to be able to defeat the claim for breach of the whistleblowing legislation by saying they honestly believed that the whistleblower had not made protected disclosures. That is a matter of objective determination for the tribunal. It also means that an employer who dismisses an employee for making unsubstantiated allegations is placing all of its eggs in one basket. If the allegations do turn out to qualify for protected disclosure status, then the employee will be in a very strong position. So that's the case of Bayat and Croydon Health Services NHS Trust. Third and final case, MPT Group Limited v. Peel, Birtwistle and Mattress Tech Limited. This is an interim injunction for springboard relief. It's obviously important to appreciate right at the start of this part of the podcast, this is an interim application, so the case is continuing, and from the case report at least, it looks like it's going to be quite a hard-fought case. As such, if I'm talking about the facts of the case, it's the facts, the interim facts pending a full trial, and which will obviously then deal with the actual determination of various factual matters. Of course, having said that, some of the facts, even if they're only interim facts at this stage, may not actually be in dispute. Having said that, the context is that the first and second defendants were the technical manager and the technical sales manager for the claimant. The claimant produces and supplies mattress machinery, equipment and parts to the mattress manufacturing industry. The two individuals had worked for the claimant for many years, but resigned together on the 4th of August 2016 and left on the 1st of September 2016. They served out their 6-month restrictive covenants, and as soon as these had lapsed, the two individuals set up a competing business, Mattress Tech Limited. It was alleged by MPT that they had downloaded confidential information, solicited each other for the purpose of the intended competing business, failed to answer questions truthfully about their future intentions, misused confidential information belonging to the company for the purpose of the design, production and supply of the machines that are very similar to MPT's machines, as well as other complaints. The primary interim remedy that MPT was seeking was a springboard injunction to last for 12 months, and they also wanted protection around various confidentiality obligations. The court, at the interim stage, started by summarising the principles for springboard relief, and they referred back to the QBE and Dimmock case, which we did a few years back now. Key provisions include, for example, springboard relief is there to restrain an individual who's got a head start as a result of unlawful acts. The purpose of the relief is to prevent defendants taking advantage of those unlawful acts. Springboard relief is not limited to cases involving a breach of confidence, but could be applied to breach of contractual and fiduciary duties. However, it is the key principle that springboard relief can only be sought and obtained when the unlawful advantage is still being enjoyed by the wrongdoer. In other words, if it has ceased, you cannot go back and get protection after the event. Springboard relief is also simply to restore the parties to the competitive position they each set out to occupy, and would have occupied, but for the, in this case, individual's misconduct. The claimant's case was that the defendants had got themselves into a position where they were able to set up a competing business extraordinarily quickly. Clearly, they said, it had been done too quickly to have been done legitimately. At the end of the day, this basic assertion failed at the interim stage, although, of course, it's an ongoing matter. There was evidence of wrongdoing in the view of the judge, but it wasn't enough to allow the judge to come to a provisional view that the claimants were likely to be right on the facts about what had happened. Accordingly, although some limited injunctions were given in respect of the protection of confidential information belonging to the claimants, their main application failed. Now, part of the reason why I wanted to mention this, I think it's a really good case if you're looking at trying to get a springboard injunction underway, as the sort of issues that the court will look at. The judgment's very clear and logical, even if it's disappointing for the claimant. However, one argument which came up could have quite a wide application. The claimant tried to argue that part of the basis for their springboard relief was that the employees had lied at the time they handed their notice in and before leaving employment. There's a duty of good faith implied into every contract of employment, and, citing Paul Goulding's excellent book, Employee Competition, it was asserted that part of the duty of good faith requires employees to answer questions truthfully. This is what the judge had to say, quote, "I am far from satisfied that these employees are under a duty to disclose their true intentions to MPT. Employees are otherwise free to make their own way in the world. I should therefore be reluctant to hold that an incident of the duty of fidelity is that, when asked a straight question, a departing employee is under a contractual obligation to explain his own confidential and nascent plans to set up in lawful competition." However, the judge managed to avoid coming to a conclusion on this point because he said that the springboard advantage allegedly obtained by the defendants had absolutely nothing to do with the fact that they had lied to the claimant when handing in their notice. Instead, it had everything to do with the fact that the defendants had allegedly misused confidential information belonging to MPT. Whilst I think the judge's comments in this case make a lot of sense, clearly the particular springboard advantage was very fact sensitive. I don't think it's a complete answer for all future cases. First, a number of the employment contracts we have seen now include express provisions and obligations on employees to answer these sort of questions honestly and straightforwardly. Unless there is some sort of contractual limitation on express clauses, then an employer could impose a contractual duty on the employee, requiring them to disclose this sort of stuff. Secondly, could it be said that the unfair advantage in the Wright case was that the employer was deprived of having significant notice about what the employees were up to for the balance of the notice period and the restrictive covenants? Clearly here it was felt that that was not an argument. I thought it could be in other cases with different facts. And obviously, of course, it almost goes without saying, if you're a director who owes fiduciary duties, that may too lead to a very different conclusion. So that's the case of MPT Group Limited against Peel, Bartwhistle and Mattress Tech Limited. So thank you very much indeed for listening to podcast number 117. We will be back in a couple of weeks' time. We may have a very special guest episode going out, which I will tell you about very shortly, probably in the next episode. But yes, it'll be a very, very special episode indeed. So I think in time-honoured fashion, it only remains for me to say that no member of the electorate was harmed or mistreated, at least by us, in the making of this podcast. I do hope everyone remembered to vote. Today is Thursday, so today is the day of the general election, so could be interesting tomorrow to see who our government is. Stay safe, everyone.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.